Facebook land. Jackie Broman here from TBA Law. So every month we do a longer version of a video on Facebook and we advertise what that event is going to be coming up. And today's topic was claims against estates. It is October and Halloween is a couple of weeks away, but unfortunately we can't do this on Halloween, so I thought the topic could be this month, horror stories around estates. So one of the main reasons I really went into specialising in wills and estates is because I absolutely hate seeing claims and messes after someone passes away. I really think there's so much value in having everything done right in the first place and doing some detailed estate planning so that it's smooth once you pass away, because when your family is grieving, it's the last thing that they want to be dealing with, a claim against your estate, and how claims against estates have torn so many families apart that I have seen. One of the main reasons I became a specialist is a case that a friend of mine was actually involved in as a prosecutor. So she was prosecuting a drink driver. That drink driver had run red lights and mowed down a couple who was crossing the street. That couple had come down from New South Wales to Victoria to watch the AFL. They'd left their kids at home, so they were having a parents' getaway weekend. So parents are dead, 2 young children at home, no wills. My friend was doing the sentencing for this woman who'd killed the couple, and there were victim impact statements done by the families of those kids, and those kids had been in family court since their parents had died because the respective grandparents hated each other. They were fighting over who the kids were going to live with and who was going to look after the money, all because there hadn't been any planning done. So that is a horror story. Now, I've got a whole lot of cases that have happened over the last 5 years or so in summary. So I'm just going to run through a few of the interesting ones, both in terms of invalid wills and claims against estates that have risen because of issues with incorrect estate planning, but also then the traditional claim against an estate that most people are concerned about is when someone wants further provision. So in Victoria, if you haven't provided for the people you have an obligation to provide for and they have a need, they can make a claim for provision from your estate. So for example, you've got an obligation to your spouse. So if you leave your spouse out of the will, they can make a claim. So in 2017, there was a claim in the Victorian Supreme Court. This couple had been cohabitating on and off, weren't married. The person died without a will, and there were no kids, so there was an intestacy. They'd been living on and off for 25 years. The woman who made the claim was an 85-year-old woman, so it was a later in life relationship running 25 years. 85-year-old spouse makes the claim. The nephew contests that there was even a relationship. The court found that there was a relationship, granted administration to the woman, and there were documents and third parties that were really relevant to establishing that elderly woman had been in a relationship with the old man who passed away, because the nephew didn't have any evidence to the contrary. So if the will had been done and it had have actually been nice and clear that they were in a relationship, the nephew would never have been able to do anything. So that's one that's happened recently. Now, adult children can also make claims against an estate if they've got a need. So a couple of horror stories around adult children making claims against an estate. Estranged children are always an issue, and we're always worried about how to make sure we leave them out correctly without them being able to make a claim. So this claim was in 2014, again in Victoria. So the estate of this one was only worth about $650,000. The person who passed away left his entire estate to his youngest child from his second marriage. So there were 3 other adult children, all of which were in financial need, and they all made a claim. So what the court did in this case was analyse the nature of the relationship between the old fellow and his other 3 children, because his other 3 children were estranged. He was only still in a relationship with his youngest child, who got the entire $650,000. So the court found that the old fellow who died was actually a very violent man and prone to cruelty, and that his children felt a lot of trauma. However, the court then went on to find, even though that was the case and the children were estranged for that reason, he had failed in his parental responsibility to them, and the court split the estate 25% to each of the 4 children. So quite a remarkable that one. The next one was very different. Again, same court, same year, 2014. This estate was really small. It was only valued at $200,000, and there is 5 children. Again, 3 of the children were estranged. So one child got $40,000, and the balance of the estate went to the daughter. So $160,000 to the daughter. 3 children left out. The court found that 2 of those children had estranged themselves from their own choice. It was nothing that the deceased had done. And because they isolated themselves, they were entitled to nothing. The 5th child, or the 3rd child who was estranged, had not purposely estranged himself. So there was actually something that had happened that the deceased had done to cause the estrangement. So that child only got $19,000. The first child still got their $40,000. 2 of them failed. 1 got $19,000, and the rest went to the daughter. So interesting case. The other category of people who can make a claim against an estate are stepchildren. So there was a case in 2016 to work out whether a stepchild of a former relationship was eligible, whether they were still a stepchild or not. And the court found that they were. The person making the claim was the child of the former partner of the deceased. So the old couple had been together for 40 years. The mum of the child passed away and left everything to the partner. They'd been together for 40 years. So the old fellow got everything. The old fellow then formed a new relationship and left it all to the new girlfriend. The daughter was 63 years old by this stage. She had a modest house worth about $400,000. She only had about $100,000 in super, and her and her husband were pensioners. So as a stepchild, she was found that yes, she was a stepchild, even though she was the child of the former spouse who'd already died, and she was awarded $100,000. Then another case about a stepchild was a disabled stepchild. This one was a little bit earlier in 2013. So we call him Bill. He's the disabled guy. He's 53 years old. He's illiterate, and he's living in a housing commission on a disability pension. So Billy's father married his stepmother when Billy was 18. So, this relationship again is over 30 years. Billy's father married his stepmother. Then Billy's father died in 2010 and left everything to his stepmother. Fair enough. He's got to look after his wife. But then the stepmother left only $100,000 in trust for Billy, and the balance went to her brother and his wife. So she didn't have children of her own. So this couple really only had Billy as a child, and she only left him $100,000. There was another $450,000 in the estate on top of the $100,000. So $450,000 went to her brother and his wife. And so Billy made a claim. He's the disabled stepchild of this woman. So he got the $100,000 and an additional $250,000, and $200,000 went to the brother and the wife. So that was, those are sort of some of the claims that we've had against estates over the last 5 years or so in the courts, in those categories of spouse, child and stepchild. So those people can make claims against estates if they're left out. So some examples there. Other examples of horror stories about estates gone wrong. So this one is a little bit funny in legal circles. In 2017, the whole country was really buzzing about this one. It was actually a Queensland case, and it was whether or not an unsent text message could be considered a valid will. And the court allowed it, funnily enough. And in Victoria specifically, we're wondering whether the Victorian court would allow it in a similar situation. So this fellow called Nickel killed himself, basically. So he suicided. He had an unsent text message on his phone beside him when he'd passed away. The text message was addressed to his brother, but he hadn't sent it. And the text message said to give the brother all his house and his super, and for his partner to take her stuff. He had initialed the text message, he'd put in his date of birth, and he'd called the text message "My Will." So there was all sorts of questions about this because it obviously wasn't signed, it wasn't witnessed, but it was done when the guy had decided to suicide. And just because he hadn't sent the text message didn't invalidate the text message as a will. The reasoning for the court for that was because if he had sent the text message, it would have alerted the brother to his intentions to suicide, and the brother may have come around and stopped it. So that is why the court granted that it was a will. Very interesting. A suspicious will. This is a Victorian one from 2 years ago, 2017. So there was a formal will done in 2008. Pretty easy. Then there was 2 later handwritten wills, a later one in 2008 and a one in 2009. So the formal will, the 2008 will, didn't include the stepdaughter getting anything. The later 2 did include the stepdaughter. Now, the stepdaughter and the husband in this case were criticised for keeping the 2 later handwritten wills secret. The deceased was elderly and vulnerable, and there was no evidence from the nursing staff or the medical staff that the elderly person had told anyone that they'd redone the will, that they'd intended to change their will, or that these handwritten wills existed. So there was no one else who knew of the existence except the stepdaughter, who had been the one to handwrite the will. So the court actually found that those 2 later handwritten wills were suspicious and weren't persuaded that they were the intentions of the deceased at all, because they'd completely changed what had been the formal will only about 6 months before the handwritten will. So, interesting one, a bit of a horror story about someone getting in their claws in and having an influence to the end of someone's life and handwriting wills for them. Another interesting one. Would a stopgap will or a temporary stopgap will still be considered valid? So this fellow Lynch, in this case went to court in Victoria in 2016, had prepared 3 pages of a handwritten document when he was going in for surgery 10 years ago. The first page wrote out who the executors were going to be, the second page wrote out who the beneficiaries were going to be, and the third page had a list. The first page was signed and had a witness, the second page wasn't signed and neither was the third, and the second and third had been done with different pens, and we don't know what time they were done. It was unclear whether the whole 3 pages were meant to be read together. And also the court decided, well, this was done as an emergency will going into surgery 10 years ago. It was a stopgap in case something happened. The guy Lynch had another 10 years after the surgery because he'd survived the surgery to do a proper will. So it was a stopgap will. It was an emergency will, therefore it was not valid 10 years later because things had substantially changed, so probate was refused on that one. So that was a bit of a horror story. All right, a invalid will and no binding nomination on super. So this one was this one's a New South Wales one, in court last year. So there was a second wife. The deceased, Mr. Grant, had done the will prior to getting married to his second wife. They were in a relationship at the time that he did the will, but they weren't living together. And Mr. Grant hadn't done a binding nomination on his superfund. It was a self-managed superfund, and the superfund was deadlocked because the wife and one of the children had appointed themselves as directors of the superfund, and no one could make a decision because they were not in agreement. The court found that the will that was made before marriage was invalid. He didn't update it after he married. It was done prior to marriage and they were living separately, so it was not a will that was done in contemplation of marriage. So, effectively, no will, no binding nomination. So what the wife tried to argue to try and get the superfund unlocked was that she was the only tax dependent available to actually get the super. The court said that wasn't a valid argument, so she couldn't get the super out that way. For super purposes, a spouse and children are dependents, so she's stuck. So basically, there was no resolution really for that case. The superfund was stuck, and it was determined there was no will, so it had to go through an intestacy process. So it's probably still playing out in court, which again is another horror story for that estate, because it certainly probably wouldn't have been the intention of that Mr. Grant for the family to be stuck in court for years after he passed away. Another interesting one, this was only decided earlier this year in Victoria Supreme Court. It was a clause in a will that has cost the estate a lot of money to go to court over because the clause is uncertain. So again, if the estate planning is not done properly, it's a bit of a horror story in terms of fees. So probate was granted on the will to the spouse and the son of this person who passed away. The issue was a clause that said $200,000 of the estate is left to the nephew for the sole purpose of enabling the nephew to construct a family crypt in the name of the deceased in a cemetery in Italy. So really badly worded. On the face of it, you might think it was clear. However, it's not an outright gift to the nephew, so the nephew doesn't get $200,000. It's not a trust for a charity because he's setting up a crypt for himself. So what is it? So the court found that it could be a trust for non-charitable purposes. So is he setting up a trust, $200,000, to get a family crypt set up? However, the court ultimately found that the whole clause was invalid, and so this didn't happen. primarily because the trust was unclear. So $200,000 for what? How many coffins is supposed to go into this family crypt? Is it just supposed to be the guy because he didn't specify? Was it up to 20 people in the family? What if other family members didn't want to be shipped back to Italy and incur that expense just to go in the crypt? He can't make family members go in there. Or was it supposed to be to move existing dead people who were in the family in Italy into the crypt with him? It wasn't clear. Nor was it clear about who was to construct it. I mean, on the natural course of reading this, it would be that the nephew would arrange for the construction. However, the wording didn't say that. It said $200,000 to the nephew to enable him to construct. So was he supposed to physically go and construct it in Italy? Because he didn't want to do that either. So, really badly worded clause, cost the estate quite a few $1,000s in court to work that out. So what a waste, and it certainly wasn't the guy's intention that that happened. So there you go. There's a few examples of some horror stories, both claims against estates and really poor estate planning. I hope that's been helpful. I will save this video onto the Facebook page so you can go back and listen to it all. I've seen a couple of people come in and out live, but I understand that it's hard to sit and watch a video for half an hour without being pre-prepared. So come back and have a listen to it. You can probably listen to it like a double time if you needed to. Please tag anyone's name in it if you think it's of interest to them. And I will leave this video on Facebook for quite a period of time so you can go back again and again if you needed to. So thank you for tuning in. I do a short snippet of legal information on Facebook Live every Monday morning at 10 o'clock, and then every month we do one of these longer Facebook Lives. So look at the events on our Facebook page and work out when the next Facebook Live is and what the topic is. It may be of interest to you or someone you know. Thank you again. I hope you have a great Friday. Talk to you next time.